Please, can you hear me? Good afternoon. Please, can you hear me?
I
Yes,
can
we
hear
can.
you, sir. Good afternoon.
It's good afternoon. Welcome to today's session. My name is please, who is please, okay. My name is Nifan Abalala Iyeli, and I will be the moderator for today's session. So, yes, as usual, we are excited to have you here for today's enriching experience. Um, we have a wonderful lineup of mentors for today's session, which is on as we have doing last week. Today is on filing of patent application. We surely be having a wonderful um, experience learning from the insight and expertise of our mentors in this topic. So today's session, as it has always been, will include mentors presentations by the mentees, feedback sessions, and question and answer from us. So I implore us to make this session interactive, engaging, and learn as much as we can from it. Let us also be encouraged to put our videos on during the session. So without wasting time, we will be starting the session for today. However, as against the usual way, today we'll be starting with the mentees presentation. I hope you are prepared for that.
Okay. Hello, can we all hear me? Can we hear me? Let's see.
Fine. Hello, good afternoon.
Yes,
Please,
good afternoon.
my sincere apologies, my network triple. My sincere apologies. Because I don't know to what extent I've been speaking before I went off. Hello?
We
Please,
can hear
to
you.
what extent am I speaking? Okay. So as I was saying earlier, um, today's session will be on filing of patent application. And as usual, the agenda of the session will include mentors presentation by the mentees, feedback sessions, and question and answer from us to interact with the mentors. I implore us to make the session interactive, engaging, and learn as much as we can from it. Let's also forget to put our videos on. Let's see our beautiful faces. So without wasting time, we begin. The first thing is to let me give us a short introduction of our mentors. Um, one of our mentors will be Mr. Rakesh Sharma. Um, he'll be speaking to us on the filing of patent application. Mr. Rakesh is Mr. Rakesh is having a thorough and multifaceted career spanning nearly a decade in patent analysis, drafting and prosecution for US and EP jurisdictions. He worked very closely with various engineering teams and supported their portfolios from idea incubation to innovation management. Mr. Rakesh has excellent understanding of patent law, claim interpretation, and drafting skills. As a seasoned professional, he is regularly engaged with various end-to-end IP services at different levels and provides intelligent IP solutions. He emphasizes more on promoting innovation for a better
What
world.
I said, since you're giving me 2,000. You get?
He loves Beatrice, please, Beatrice. He emphasizes more on promoting innovation for a better world. He loves drafting patent claims, keeping all the infringement perspectives in mind. Furthermore, he has a strong bent of mind towards IP automation and sound knowledge of various IP tools and techniques that can be used for either improving quality of IP or increasing the overall productivity. He's also an excellent mentor and possesses all the leadership qualities required for a successful IP professional. Undoubtedly, we are going to learn greatly from Mr. Rakesh. And also, we also have Mrs. Mrs. Amusa Shukurat Mudukiola, who is a seasoned intellectual property consultant, analyst, and educator. Sorry, okay, thank you. So Mrs. Shukurat is a seasoned intellectual property consultant, analyst, and educator with public sector experience. She holds a master's degree in intellectual property from the prestigious African University Zimbabwe in collaboration with the WIPO and Japan government. Shukurat is an alumna of the World Intellectual Property Organization, a member of the WIPO International Network for IP Education, as well as a training facilitator at the Next Innovation Hub. She was a member of the planning committee for the WIPO National IPSC Competition 2023 and the resource person at the National Intellectual Property Conference, NIPC. Shukurat is an accredited agent of the Intellectual Property Office in Nigeria and a pioneer of the Intangible Knowledge, an educational platform which is responsible for fostering, among other things, intellectual property advocacy, awareness, and education. And undoubtedly, we have a seasoned training facilitator in Mrs. Amusa to be our mentor today. However, as usual, or as against the usual, today we'll be starting with the presentation by the mentees. So I hope our mentees are ready for their presentation. Hello, mentees.
A group presenter for
Yes, sir, we are ready, sir.
All right, please go ahead.
So my presentation is about also let me share my screen for comment.
Okay, Akinwale, we are with you.
Yes, I want to share my screen first so that
All right.
so basically what we are with type of our program, we'll be discussing about optimizing patent application strategy, a comprehensive analysis of filing processes, duration and priority consideration in a professional, local, regional, and international context. So basically, we'll be starting off by defining what professional patent filing is. Basically, we should before I go forward, we should be able to know that there's a difference between professional patent filing and patent filing in itself. So professional patent filing basically is a short-term means of protecting an invention or concept and requires a less effort and expense than a formal patent application. So basically what he's trying to say is that before an inventor has the right or is at liberty before filing a patent application, he can file a provincial patent filing. So basically what this provisional patent filing simply means that is a short-term process through which an inventor can protect his rights before filing the real patent application. So what it does is that is a short-term short-term protection that an inventor can take advantage of through which his ideas or basically his invention is protected by against a third party. So what this simply means is that before filing is the real patent application, an inventor can basically file a provisional patent filing so as to temporarily protect his rights uh, prior to the time you will be filing a patent and application in itself. So before you file a provisional patent filing, there are some steps that the inventor will have to take, and one of it is that the patent must conduct a search. We would understand that during our last presentation or previous classes, where we would make reference to the fact that for every patent application to be processed or to be to be filed, an inventor would have to carry out a search, and that basically what that search basically helps is that it helps the inventor to search or to inquire about whether his invention or part of his invention has been already been patented by a third party, so as to not to infringe in that other party's rights. So an inventor must make sure that they carry out that particular search so as to make sure that his invention, whether the features of his invention has not been patented, so that there won't be any form of a conflict of rights in that aspect. Then the second aspect is that the accuracy and description of the invention, like I said before, that there are some particular invention that it is descriptive in nature. Let's say, for example, if a particular inventor invents a particular machine that processes Gary, and one will be able to note that is a machine, and a machine has a descriptive feature. So for a particular patent or for a patentee or an inventor to protect that particular right, you must establish that okay, this particular invention that I'm about to patent has these particular features, maybe the way it is designed or on a part of the component that encompasses the entire machine itself. So there must be accurate description of the invention. So then the third one is the filing of a professional patent application. Like I said earlier, I said that there is a huge difference between filing a patent application and filing a professional patent application, like I said earlier. So if a particular patent application is about to be filed, that is if a provisional patent application is about to be filed, there's some certain content that it must consist of so as to encompass the whole idea of the inventor's creation. And one of these is the title of the invention. Basically, what he's trying to say, okay, like I said earlier, I said a machine. Now, if a particular inventor is about to or wants to patent a particular invention, what name are you going to give to that particular invention? Is it a machine? Is it is it a furniture? Is it a door? Is it a phone? So that particular patentee must be able to give that invention a title so that it can be easily be identified from other parts of patent products. Then the second is the names of the all inventors. There are some certain instances that a particular invention will not only carry a particular inventor. There's a couple of persons can come up together to create a particular invention. So if that particular invention does not really carry one name but encompasses more than one name, that particular name or names of the patentee of the or the inventors should be included in the application. And the reason why it is being done is that if an invention invention carries three names, but in their application they only wrote one name. Now what basically is this telling us is that only that particular name that is being put down in the patent application has exclusive right to that particular invention. So the rest of the two or other parties that originally owns that particular idea will not be protected. So that's why that's why it is always an imperative for us to make sure that if a particular invention has more than two inventors or more than one inventor, those inventors' name must be included in the professional patent application. Then the third one is the inventor's home address and residence. So the inventors, the home address of the inventors, where they live, should be included in the professional patent application. Then the third one is the names, registration number of the attorney or patent agent, the name of the registration number of our attorney or patent agent. If one, there are sometimes that a patent can file is a professional patent application in himself or herself, or he can file same through an agent or an attorney. So if that particular provisional patent application is done through an attorney, so that attorney's name and address would be included in the patent application for easy identification. Then we have the address where the patent registry can send correspondence. And we must also know that we are all humans, and there are sometimes that we can omit some certain information that are so vital to a particular application. So if peradventure when filing or we're putting down this patent application, the registrar of the patent in office can note this omission or errors. So it will be advisable for the inventor or the inventors or patentee, as the case may be, to always include their correspondence, so as to make sure that if the patent registry or registrar notes a particular error in the application, they can easily be revert to that. That is to say, the patent registrar can easily get hold of the inventor or inventors, as the case may be. Then the appropriate fee must be paid so as to finalize the professional patent application. And we must also know that there are requirements to this particular provisional patent application. And one of it is that a detailed written description of the invention, like I said earlier, for a particular patent to be, but for a particular professional patent application to be granted, and the description of the invention must be done. If and that has to do with if the inventor has to draw the shape, the size, the components, because there are sometimes that if a particular invention is being created, it may consist a series of components that will make the invention whole. So it is safe for the patentee or the inventor to make sure that each component are being drawn, so as to make sure that these are the components that makes my invention whole. So, and also the background of the invention, this background of the invention has to do with it can include what the invention is all about, just a brief description. You don't really have to go into details per se, just a brief description of what the invention is about, so that the patent registrar will be able to know, okay, this is what you are about to this is what we are about to approve, so that it won't be it won't in any way conflict with another person's rights. Then like we have the drawings, like I said earlier. Then the detailed description basically is still amount to the fact that that is why it is being emphasized that if you are if a particular invention has to do with a machine or a particular product or a particular item or equipment that that for that particular machine or inventor to be able, so that one can be so that one can identify it at a glance. It is quite imperative that that particular invention is being drawn, a description, the entire description of what that invention is all about. And we have the advantages of filing a professional patent application. There are series of advantages, but I highlighted four. The first one is that is a stake in ground. That's the advantage of filing a professional patent application. The first one is that is a stake in the ground to lay a claim on your idea by setting a priority date. So, when I was making reference to the fact that there's a difference between patent application and professional patent filing. So what this is saying is that it gives the inventor first hand first hand protection against other persons. So it basically means that you can, before filing the appropriate patent application, you might as well file a professional patent application, so that you will be able to protect that particular idea, temporarily, so that because there are instances in which your idea is in progress. You are still trying as much as possible to incorporate some components or some ideas into that particular invention. So you need not wait till gather or conclude that particular invention. You can file a professional patent filing. You can file it so as to have priority over other persons. And the second is that it allows you to discuss your idea publicly with less risk. And what this is trying to say is that you can definitely hold like a symposium or a seminar in which you can display your invention. Then you can call public to at least to maybe appreciate or criticize, or at least to make for them to give out their own personal idea of what that particular invention is all about, so that if there's any need for you to adjust or to improve on that particular invention, you will be able to do that. Then the third one is allows you to publish research with less risk of someone else filing a patent application on your idea. We've discussed that before. It gives you prior interest or prior rights over other people if you file your professional patent application, because you need not wait till you file your patent application in itself. You can file the professional patent application so as to protect your own interest. Then it gives up to 12 months to gather everything. Filing it gives you up to 12 months to gather everything for filing a non-professional patent application or an international patent application. So basically, what this is trying to say is that there's a particular timeline that this particular professional patent filing would expire. So before, you can't file a professional patent filing and just leave it at that and saying, okay, your interest is protected for life. No, there is an expiry date for that provisional patent filing. So basically, what professional patent filing deals in is that it gives you just temporary rights to protect your idea against other parties. So then we move to local patent filing. There are a series of patent filing based on jurisdiction. So in Nigeria, the patent filing is under NOTAP, that is National Office for Technology Acquisition and Promotion, and our Patent Design Act of 1971. Those two, the act and the office in itself regulate local patent filing. Then the regulatory body, when we are talking about patent and design, we have like we've made mention in our previous classes that we have patents, we have copyright, we have trademark, we have trade secrets. We have so many instances that intellectual property is protected under. So part of the regulatory body under the local patent filing, we have the trademark registry, we have the patent registry, we have the design registry, and under the Federal Ministry of Industry, so trade and investment. So those three offices are under one particular office, which is the Federal Ministry of Industrial Trade and Investment. Then the NOTAP, like I said earlier, is deals with the regulatory body for filing local patent applications. Then the NOTAP oversees foreign technology transfer related to patents, because if you are protecting a particular rights or an invention in your locality, or you want to protect it from foreign from other foreign from other foreign invention or inventors, you must make sure that this particular patent filing is done under NOTAP. Then we have the international filing from Nigeria. You can file a patent application from any country, like it is being said in our slides. Nigeria is a member of our Paris Convention, allowing convention priority within 12 months, and Nigeria is not a signatory to Paris Cooperation Treaty to direct PTC national post entry is possible. So basically what this is saying is that although Nigeria, the PTC has been ratified by Nigeria, is a member of Paris Convention, but under the Paris, Nigeria is a member of the Paris Convention, but under the Patent Cooperation Treaty, we are not a member. So in order to protect your rights internationally, since we have ratified Paris Convention as our local law, so your invention is protected under Paris Convention. When you are dealing with that, when you want to file a particular invention in another country, but you are basically saying that you want that particular invention also to be protected in Nigeria. So by filing it under Paris Convention protocol, your right is being protected internationally. Then we have the filing procedure in Nigeria. We have you must prepare your application. And we are in our you said a written request with the applicant. When you want to file an application, but you must take cognizance of the fact that you must first of all search do a public search so that the invention you are about to patent is not infringing on any other person's rights. And and also the application must include claims. So basically, that claims is talking about the scope of protection, how big or how wide or how detailed or how narrow. Our last class we talked about narrow and broad claim. So you must be able to choose, based on your invention, would your invention cover the narrow claim, or will your invention cover the broad claim? So you must be able to, identify these two types of claims so as to make sure that you are protected in its that your invention is protected in its entirety. And we have the drawing that has to do with the distribution of the invention. If you have to describe how your invention is, so it is more advisable to describe it so as to know that, okay, this is how my invention is, and this is the component that encompasses my invention. And we have the abstract summary, and then afterwards you submit your application to the patent registry in Abuja. Basically, what this patent registry does is that they go through your patent application to also, look at their, because they also have to they also have to search so that what you are about to patent does or has not already been patented. So they also must, go through their own personal research so as to make sure that you are eligible for this particular invention that you want to patent. Then, like I said, examination of for formality, they would examine your claim. You examine your claim, and if there's any need for readjustment or addition or subtraction with respect to your application, so that is why they would have to revert back to the inventor to the address that he or she would give provide when filing the application in itself. Then, if the office, after going through this process now, and come to the conclusion that yes, you are fit to, your particular application is fit to be granted, so they will grant that particular application, and that application is protected for a period of 20 years, but you can definitely renew, because once that particular period elapses, your patent is now in a public domain, and any other person can pick that, content or that description or that invention itself, and work on it and patent it as their own. Because if you say your patent application has been granted, and the 20 years grace has elapsed, and you do not renew, what this basically is saying that your patent now go back to the public domain, meaning that your exclusive right is not no longer exclusive in itself, or in itself. Then we move to regional patent filing system. Now we have the OAPI. OAPI, that is the African International Proprietary Organization, which its headquarters is in Yaoundé, Cameroon. And OAPI is a French-speaking body, that is to say it encompasses countries, part of some, not all French countries are under OAPI, but there are some certain countries that are registered under OAPI, or that is they are members of the OAPI. We have the Benin, we have Burkina Faso, we have Cote d'Ivoire, Guinea, Mali, Niger, Senegal, Togo, and the rest. But we must know that Nigeria is not a part of OAPI, because Nigeria is not a French-speaking country. Then under the, we talked about the local patent filing, and we are the regional patent filing system. There's a difference between the process through which they file their application differs from the local to the regional. So based under the OAPI, the filing system is that the application is a single application which covers regional coverage. Basically, what is saying is that if you file a particular application, patent application and you are in Guinea, you are in let's say you are in Burkina Faso, and you file your patent application under OAPI, that patent is not really protected under that particular country you filed it, which is Burkina Faso. It is also protected under Benin, Cote d'Ivoire, Guinea, Mali, Niger, Togo, and the rest of members country who are under OAPI. But it's in a way it saves it saves costs, so as and basically when I mean that it saves cost is saying is that you need not file, or you don't have to file, you know this patent application under OAP in all the French-speaking countries that are members. You only need to file in just one, and your right is protected in under the rest of the members of countries who are under OAP. Then we have the patentability criteria, similar to Nigeria, we talked about under the Patent Act and Design Act, Patent and Design Act of 1971. That is section 1 of the act, which talks about the patentability criteria that for your application to be successful or for your invention to be patented, it must pass through series of tests. We have the novelty, that is to say it must be new. It must be new. Also, it must also be even if it's not new, you must prove that is an step to is an improved step to a previous invention. Then we have the industrial applicability also, that for your invention to be patented under WAPI. No, it must pass through this text, like I said earlier. And we also have the filing requirements, a formal request for a patent that is a full patent specification. It must include your description, the claims, what you want to protect, whether you want to go under the narrow claim or whether you want to go under the broad claim, and if there's any need for you to draw, because most of it is quite advisable that if you are dealing with anything that has to do with machine or anything that has to do with things that you have to you have to protect that particular invention in its entirety. It is best advisable that you drop the description of how that particular invention is. Then we must also note that WAPI and international WAPI is a member of PCT also. Basically, what he's trying to say is that if you file your patent application under WAPI, your rights in a way is
Actually,
staff. So, okay, you also have to make sure that your right is
yes,
also
please.
staff. Okay. You must also, I'll be wrapping up.
3 minutes more, please. 3 minutes more.
Okay, yes,
You are
yes,
even overstretched.
yes, I'm done. So your rights is also protected under OAP, because OAP is a member of PTC. So if you file a patent application under OAP, PTC also covers you also, and it also recognizes Paris Convention. Then also we talked about jurisdiction of a patent filing application in Nigeria. We have in our studies or in our presentation, we highlighted these countries: Nigeria, United States, European Union, United Kingdom, Japan, and China. In Nigeria, the time for filing a patent application in Nigeria claim is for maybe 12 months. So if between 1 month to 12 months, you'll be able to get your patent application ready. In United States, it differs, it covers between 2 to 5 years. In a European country, 3 to 5 years. In UK, 2 to 3 years. In Japan, 2 to 4 years or 2 to 3 years, depending on the patent application in Japan. In China, it's 3 to 5 years or 3 to 4 years, as this may be. Then we have the factors that influence process timeline. That we have the examination request. Like some jurisdictions such as China, you must request a substantive examination separately. And we have the backlog. So many people are filing patent applications. So there are some times that the patent office registry would have more than enough to deal with. Then we have the type of patent. Also, when you file a patent application and you want your patent application to be granted as soon as possible. That as soon as possible is determined by the type of patent you want to patent, and the type of invention you want to patent. We also said that the delays caused by opposition and appeal. Like I said earlier, if you file a patent application and the patent registry rejects it, you have the right to appeal that particular, rejection. So that will also form part to which this patent application will take longer period to be patented. So basically, what we are trying to say is that in this professional patent filing application, it varies from one region to the other, and we must also our take home is that there's a difference between the patent filing application itself and provisional patent filing. Thank you very much.
Thank you. Um, that was a good presentation. Thank you very much. So I believe our mentors will be guiding us and making their comments and suggestions on it. So we'll be going on to the mentors presentation now and comment on the mentors presentation. The first one will be Abby. I think Mr. Rakesh is online. Yes. I think Abby Mr. Rakesh first. Mr. Rakesh, sir, please, are you online, sir?
Mr. Rakesh is not in class.
Can you hear me?
Oh,
Dennis. I was logged out for some seconds.
okay. So, okay, man. You can hear you, man.
Okay. So yeah, I listened in the presentation for a while. Well done on the presentation. It was well presented, though the terminologies were kind of mixed, but it's one of those things you are just learning. So the presentation for today, the topic is basically patent protection, like how filing patent application. How do you file patent application? And before you file a patent application, there are a lot of things you need to look at, which we've treated in the past weeks. However, when filing your patent application, you still need to bring back some things. You need to ask yourself some things, such as what exactly are you trying to protect, to patent? Is it a product? Is it a process? Is it a product by process? Who exactly are your competitors? So that when you are drafting your claim, you draft your claim in such a way that it is broad enough, and that your competitors are not able to find a way around your claim and invent around your patent. That's a question you want to ask yourself. You also want to have to ask yourself, when do I want to file this application? When exactly do I want to file? Do I probably have maybe a seminar that I might need to present this invention? So when exactly am I filing? Will I be able to file before I present, or am I going to file after I present? In an instance where I'm filing after I present, is there a kind of grace period opportunity as provided by the Paris Convention in the country where I want to file, so that I'm able to benefit from grace period even after I have filed even after I have disclosed my invention? So these are some questions you want to ask. You also want to ask yourself, where do I want to file my invention? Where do I have a market? Which country will this invention benefit more? Where exactly are my competitors filing? Where can I find good markets wherein my competitors don't really have much, should I say, customers or consumers in that region? So these are questions you need to ask. Now, when you ask this question and you are able to answer the question, it now gives you a bullet point of, okay, this is how I'm going to file my application. Let's take, for example, What do you want to file? Or what is the invention about? Is it a product? Is it a process? Is it a product by process? Now, say for example, you are doing a product by process. While drafting your application, you want to ask yourself, do I want to file one application that has two different invention? You want to ask yourself, is there a unity of invention in this thing I'm doing, or do I want to file two separate applications such that one application carries the product, the other application carries the process? Because if you are filing like a process by product kind of application, that means it's two invention in one application, and as such there has to be a unity of invention. The invention has to correlate, it has to relate with one another. Not that the process is talking about how to use magnesium oxide, and the product probably is talking about how to use oxygen and carbon dioxide. So you want to make sure that there's unity of invention if you are filing a two-in-one kind of patent. But if you are doing like separate application, then you want to see, when do I want to file this and when. Now let's look at when you want to file. You've determined that, okay, this invention, I'm going to file like a two-in-one because it has unity of invention, or because I'm going to file separately. When do I want to file? And how? Which process do I want to take? Do I want to follow the Paris Convention, or do I want to follow the PCT route? If you are following the Paris Convention route, then you have the opportunity to file a provisional patent application, just like the presenter was talking about. So I didn't really get the sound, but it was sounding like it was mentioning um I can't really get what, but it's provisional, actually, a provisional patent application. And what provisional patent application does, it's like it's just for you to save, to have a filing date. Basically, you are trying to secure a filing date, even though your invention, or you are not yet done with the application you are drafting. So what the provisional patent application will do for you is, you get a filing date secured, and before or between when you filed and 12 months, like from when you filed and 12 months, you have to file a non-provisional patent application. So the non-provisional is what the facilitator was calling the main patent. But like I said, these terminologies varies in different country. In Nigeria, we don't have anything like a provisional patent application or a non-provisional patent application. A patent is a patent in Nigeria. So, but in other countries like the US, they have provisional and non-provisional. So in that instance, if you know that, oh, I want to secure this particular filing date such that anybody that filed after me, but person's patent is not going to invalidate my own because they are filing first. So you use that provisional patent application to secure that date, but you have to make sure that you file like between 12 months from the filing date. 12 months from that time, you need to file the main non-provisional parent application. And the non-provisional, everything has to be complete. Your diagrams, if you have diagrams, your claim, everything has to be complete. But in the provisional, you necessarily don't have to put your claim and the necessary specification of the patent. So when you now decide on how you want to file, you also want to decide, like I said earlier, is there any possibility of you disclosing this invention before you file? So when you look at the Paris Convention deals with three major things. Number one, it deals with national treatment. That is, the national the nationals, like members who are people who are members of the Paris Convention, they have to treat patent application from other member states the same way. That's national treatment. Then there's the other aspect of priority dates. Priority date is when, if I, for example, I file my patent application in Nigeria and I also want to file, let's say, in Ghana, provided that these countries are members of Paris Convention. So if I file in Nigeria and I also want to file in Ghana, but I want to maintain the same dates I filed in Nigeria, then I'm gonna file a priority. I'm gonna claim priority rather. I'm gonna claim priority of the date in Nigeria while filing in Ghana, provided that I file 12 months from when I filed in Nigeria. So that's claiming priority. So if I file in Nigeria, let's say 12th of January 2024, then I have to file not later than 11th of January 2025 in Ghana. Because if I file, let's say 12th of January or 13th of January, I won't be able to claim priority to what the one I filed in Nigeria. So that's how priority works. So when I now file in Ghana, I'm not going to the date in my application will not be 11th of January 2025. It's going to be 11th of January 2024, meaning that everybody that filed after or everybody that filed before I file in Ghana cannot invalidate my application. Why? Because I'm laying claim, I'm taking priority of the one I filed initially. I don't know if you understand. It's kind of dicey, but that's how it works. So that's priority under Paris Convention. So, like I said, Paris Convention gives you the opportunity to benefit national treatment. That is, you have to treat every member of Paris Convention the way you are going to treat your own the members in your own country. So the way you are going to treat a Nigerian patent is the same way you have to treat a patent coming from Ghana or any other Paris Convention member state. Then you also have priority date. Then you have grace period. Grace period is it gives you the grace of 12 months to file your application, after which you might have disclosed your application. So these are the kind of write-up that you're supposed to have in your presentation so that people are able to understand, okay, where are you? You are able to link what you've learned in previous weeks, link it to this one that you've learned now. So it's easier to understand, even for those that probably are going to read your presentation at the end of the day. So there has to be that correlation. It has to correlate, because when you talk about provisional application, what or which provision mentions provisional application, which treaty, which convention, that wasn't mentioned in your presentation. So you just know that there's something called provisional application, but where does that come from? You need to understand all of that. So the Paris Convention, like I said, will give you the provisional application opportunity, it gives you national treatment, it gives you grace period, and it gives you priority. Now, not all countries give grace period. So that's why I said these laws, Paris Convention just give us law generally. It's now left for each country to determine if in their own jurisdiction they are going to adopt that what Paris Convention has stated. Are they going to adopt everything? So some countries also the length, the period varies. In Nigeria, I think grace period in Nigeria is, I think it is 12 months for patents and 6 months for trademark and industrial design, if I'm right. In other countries, it is 6 months for patent. There are some countries that don't even enjoy grace, they don't even give you grace period at all. So before you file or before you do anything, you need to understand the rules or the laws or rules governing the patent application in each country. So that said, that's the Paris Convention route. They will now look at the filing now. So when you file using Paris Convention, if you file in Nigeria, let's say you file 0 to 12 months. 0 months is when you file, and you want to file in another country. Within that 0 to 12 months, you need to claim priority in the country you want to file. So that's how priority works. If you don't claim priority within that 12 months, you cannot claim priority again once that 12 months expires. And so that's gone. You have to go and file newly in the jurisdiction you want to protect your patent in. But if you are going through PCT, PCT will give you 30 months period before you can even decide and say, okay, I want this application, or I want to designate this country, or this country, so that my application can be filed in all of this country. But with Paris Convention, you won't have that opportunity of international search report, preliminary reports, ISA authority checking your patent and all of that, like you will have in PCT. You won't have that in Paris Convention. Once it is 12 months, then they send your application to the country you are claiming priority. receives your application immediately. Nobody is doing a search on your behalf. It is that country that will now do the search and decides if your application can be granted in their country or not. But with PCT, you have different processes that even after your home country have done your search, be it a formal your search and also examination, be it formality examination or a substantive examination, they are still going to do some kind of examination on their own. They are going to do the international search report. Then you have the ISA, that's the national search report. You have the preliminary search report. You have the examination report. If you're not satisfied, you can request for a preliminary examination report before you now even get to the national phase. National phase is where the application gets to each designated country. And before then, when the result comes out and you feel like, oh, the report is advising you to work more on your invention because it's probably is lacking novelty or it's lacking inventiveness, you can decide to withdraw your application, go back, sit down and redraft your application, then you submit it. Because the moment you send it and it gets published, then that's it. Once it's published, you can't file application for that invention again, and it goes that way. And yes, just like we have the route, international route, national route, and regional route. It applies to all IP rights that deals with registration. So when it comes to international route, like I said, the international route is the PCT route. Then when it comes to regional route, like the presenter mentioned, we have ARIPO, we have OAPI, and we have EPO. The EPO is the European Patent Office. ARIPO is the African Regional Intellectual Property Organization, and we have OAPI. OAPI is the Africa Intellectual Property Organization, and that deals with the French-speaking countries. But ARIPO deals with English-speaking country. And I need to mention that ARIPO does not operate a unitary system, but OAPI and EPO operates a unitary system such that whenever you file in ARIPO, you have to designate the countries you want your application to be protected in. But when you file in OAPI and EPO, your application gets protected automatically in those countries. Because, for example, like OAPI does not have IP office in each of those member states or in each of their states. It's just OAPI that governs all other countries or states that surrounds OAPI. So whatever you file in OAPI, is protected across all these 17 countries thereabout in OAPI. What else was mentioned? I think he also mentioned the aspect of, yes, the aspect of NOTAP. So NOTAP is the National Office for Technology Acquisition and Promotion, if I'm right. Yes. National Office for Technology Acquisition and Promotion. Now, it mentioned that NOTAP is the office in charge for patent, which that is actually not right. NOTAP is not the one in charge for patents. The patent registry under the FMITI, that's the Federal Ministry of Industry, Trade and Investment, the patent registry is the one in charge of patent application. The only thing NOTAP does is that NOTAP tries to make the work kind of less stressful. Say for government parastatals who are trying to file a patent application, instead of government parastatals to go through patent registry directly, they go through NOTAP. And NOTAP finds a way to get the application to the patent registry. NOTAP does not grant patents. They don't grant patents. All they do is they just have like a third party to get the application and they send it to the registry. If registry says no, they send you a notice back and say, okay, your patent cannot be granted because of so reason. You should work on this or work on that. I also have to mention that in Nigeria, we don't do substantive examination. We only do examination as to formality. Formality in the sense that we only check if your request form, your name, and everything is aligned. We don't go deep down to check if your invention is new, is novel, is inventive, or is industrially applicable. We don't do that, except when it gets to a situation whereby somebody opposes a patent, or maybe somebody comes and say, oh, this person is infringing my patent. And because we want to do due diligence, at that point, we cannot decide to say, okay, let's put this patent side by side and see if truly this patent meets up with the criteria for patentability. But aside that, on a normal day, you want to file a patent in Nigeria, we only do formality examination. And most African countries as well do basically formality examination and not examination as to substantiveness. And this is the reason why most of our patents cannot stand international standard, because they are just examined based on formality and not substantiveness. I also want to mention the aspect of inventors. So on your request, whenever you see a patent application, like we did, I think that was 2 weeks ago, when we were trying to search a patent, you see that on the cover page of the patent, we could see the inventor name, you could see the publication date, the filing date, the country it was filed in, and all sorts of things. So the request form is there so that you can put in all your information, just in case somebody is interested in picking up your invention and they want to license, they are able to reach out to you to make that agreement. Now, we also need to understand that inventor is different from owner. So you will see that in patent application, there will be inventor and there will be a spot for owner, or we call it statutory. There's something like called statutory ownership, and the I can't remember now, but it's two different terms. So the statutory owner is the person that filed. The inventor and statutory inventor. Now, the inventor is the person that worked on the application, like you are the one that put A and B together. But the statutory inventor is the person that filed, or the person on behalf, or the person in which you are filing for. Say, for example, you work with an organization and you come up with an invention that has to do with what the organization employed you for. You will be listed on the application as the inventor, but the organization will be named the owner, like the statutory inventor, because they are the one that own the invention, but you will be named as an inventor. And the reason why the law says that every inventor will be named on the patent application is because when they commercialize that invention, a percentage goes to the inventor because of their work done on that invention. So whenever an invention gets commercialized in a work on an organization or an environment that people are working for you, a percentage of whatever it is you get through license of that invention, you have to compensate the inventors who worked on that invention, because that does not necessarily mean that they own the invention. But law varies in different jurisdictions. In some other jurisdiction, they will say, like in Nigeria, the law says if you're an employer and you work for if you're an employee, an employee works for an employer, whatever you do in the course of your job belongs to your employer, as long as it has to do with job description, or as long as you use the resources of the organization to work on that invention. In other jurisdiction, what it says is that the inventor owns the invention. However, the inventor has to sign a transfer of ownership rights so that the employee or the organization can own the invention. So it all depends on the country and the jurisdiction, what the law says. Then let's talk about the application process. So the application process is you submit you fill in a form. You can do that online, or you can go to the registry to file an application. So once you file your application, you fill in the form that has all your information. Then you put in, you attach your write up, like your patent document. Now you attach a patent document that has the title, the abstract, the field of invention, the description, background of invention, detailed description, drawings, if any, and claim. So those are the specifications that's supposed to be in that patent application. So you attach that patent application, you pay a set of fee, because if you don't pay, nobody's going to process it. Yes, you pay and it get processed. they do their formality examination, and if the examiner feels like, okay, this is good, they grant you a patent and you get a certificate at the end of the day. Oh, sorry, they publish it. Once they feel like, okay, this is good enough to be granted, it gets published in the trademark publication journal. And when it gets published, that means they are opening it up for people to come and oppose. So if at any point somebody's feel like, oh, this person's invention looks similar to mine, or the person is infringing my invention, then you can now go ahead to oppose. It is at that point I said that they'll now have to like look at those inventions side by side to determine the novelty, the inventiveness, and industrial applicability at that point, so as to know who exactly is the rightful owner, because two people can't own the same invention. And we also need to understand that Nigeria operates a first to file system. So the person that filed first has more upper hand compared to the second person. And yes, if there's no opposition, you proceed to get your patent certificate, that is, your patent has been granted, and from there you have to keep paying a maintenance fee to keep your patent running till the next 20 years. And once your 20 years is complete, what happens is that your patent goes to the public domain and is available for every other person to pick up, to work up, to improve, and probably file a new patent application. And you as the inventor, you also need to find new ways to probably update your invention or come up with new invention so that you can have inventions protected. So one last thing I didn't mention is that there's an alternative for patent. So for those who their patent application lacks inventiveness, there is something called the utility patent. So you can file a utility patent. Utility patent requirement is less stringent compared to that of patent. So when it comes to utility patent doesn't really require inventiveness. The inventiveness is very minimal compared to patent. And so with utility patent, your work just has to be new and not really inventive. Then if you now feel like, so the utility patent is just like is just like the provisional patent in some other countries. But with utility patent, you have to submit everything that you need to submit at once. Then if at the end of the day you are able to work on the invention and it gets that standardization that it can pass for patent, then you can proceed to file for a patent application. For utility patent lasts for, I think, 7 years, between 7 to 10 years. The patent lasts for 20 years. We also have something called the business model. The business model is, I think, business model is also between 7 to 10 years protection period. It's just for you to patent a business model that you feel like it's new to you and you don't want it exploited by somebody else. The last thing I want to mention, skip my mind. Um, yeah, I think that's it. I think that's it. Yeah, that's it. Thank you. Am I still on this call?
Listen, thank you very much, man. Thank you very much, man. As usual, that was very rich and outstanding from you. At least for me, I gave one thing amongst the others. One thing
So,
that
so
told us
sorry to cut you short. Nifemi. The last thing I wanted to
all right.
mention was alternative for patents, which is trade secrets. So I don't know if some of you who are here are also in the intellectual property class for IP and business, as well as IP for creators. You would have heard your tutors or speakers talk about the difference between patent and trade secrets. So I mentioned that if you don't want to go for patent, you have alternatives such as utility model, you have alternatives such as business method, and you also have alternatives such as trade secret. Now, trade secret is that type of intellectual property right that doesn't require registration. And as such, the only thing you have to do is keep quiet about it or put in measures to make sure that it is secret. For example, the measures you can put in is using an NDA or a non-compete clause. Take, for example, Coca-Cola KFC. These are example of companies that have strived on trade secrets and they don't have patents, but they make sure that they are protecting this trade secret in as such that it doesn't end up in anybody's hand. And before a confidential information can qualify as a trade secret, it means you must have put in measures to keep it secret. And it also has to be something that gives you competitive advantage. And it also has to be something that if it is being disclosed, it's going to affect your business on the long run. So these are alternative to patent that you can explore as a business owner. Yeah, so that's it. Thank you so much.
All right, thank you very much, yeah. Duly noted. So I was saying earlier, amongst all I've learned and still one thing I want to put on to the fact that before filing any patent application, you have to know who are your potential competitors, when to file, is it before you disclose or after to the property, and where to find the patent. That is just a bit of what I learned here, and I believe the mentees also learned more. In case of any question from the mentees, I'm not sure Mr. Rakesh is online. Pending when she join us, any question from the mentee? So, Mr. Shuko, mentees, any question? Mentees, any question?
Yes, I have a question, sir.
Okay,
So
you can just go ahead.
so my question goes when Mrs. Amsa was talking, she made mention of the fact that in Nigeria there is no such. It was when I was making my presentation, I made reference to the fact that in Nigeria, for a patent application to be approved or granted, that the patent registry has to make they have to make their own personal research. But Ms. Zamka said that research is just formality. Now, my question is that in an event that a particular inventor wants to patent an invention, and that particular invention is being patented, but the mistake that the patent registry failed to make was that they didn't do a thorough search to inquire whether that particular invention has been patented or not. So let's now assume that that particular invention has been patented, but they not granted patent application to the new inventor. So now, what would now be a way out or a remedy for the previous inventor and the new inventor whose invention are now patented, having the same or similar description? So what is now the remedy for both parties in that instance?
I'm not sure I heard you clearly, but I think you are trying to ask what will be since they don't carry out substantive examination, what will be the remedy if they grant patent to two different persons on the same invention? Is that it? Is that your question?
Yes, ma'am. Of course, ma'am. Yes, ma'am.
Okay. So in as much as they don't carry out substantive
Yes, ma'am.
examination, so in as much as the patent registry does not carry out substantive examination, that doesn't mean that they don't carry out search. Examination is different from search. So if you want to do anything now, you have to do a patent search first. And when you do a patent search, they are going to issue you a slip that tells you if this patent is available for you to proceed with registration or not. So at the point whereby you want to file the application, they are going to request for your set slip. Okay, so that doesn't mean that because they don't carry out substantive examination, doesn't mean that they don't carry out search. So at the process of search, they have the report of all the applications that have been filed and those that have not been filed. So they can tell you at that set point to say, okay, this application is already filed. Okay, this one is still new. You can come and file and like that. But the only thing is that substantive examination is that they don't look at it as to substantiveness to see the newness or the inventiveness of that application, not if it has been filed before or if it already exists in their database. Does that answer your question? Does that answer your question?
Yes, ma'am.
Okay, and I also mentioned that peradventure when there is clash, like because of they didn't carry out substantive examination, if somebody else probably opposes the application during the publication stage and says that, oh, you've already granted me this application, why are you granting this person a similar application? Or maybe the claim is infringing on their own claim. At that point, then we'll look at both inventions, then now carry out those searches, those examination of novelty and inventiveness. But they don't do it at the registration point and say, okay, we want to carry out substantive examination. It's only when there's a need for it as regards to infringement, then they have to carry out examination. Does that answer your
Alright.
question?
Yes, ma'am. Thank you very much, ma'am.
Thank
So
you
I
so
think
much.
there's a question
Yes,
from
there's a question.
Beatrice. Okay, so according to the Patent Act, there's something called a true inventor and a statutory inventor. A true inventor is the inventor that worked on the invention. A statutory inventor is the person that is filing for the protection of the invention. So the statutory invention is usually what we call the owner. Let me just bring in copyright in this instance. When we talk about copyright, we'll talk about author and owner, right? So look at it in that instance. The true inventor is like the author. The statutory inventor is the owner. So the fact that you might be an author but not be the owner also applies in patents. Yes, you are the true inventor, but that doesn't mean that you own the invention. It is the statutory inventor that owns it because it's the statutory inventor that is going to file for the protection of that invention. So even if the true inventor is filing for the protection of the invention, the true inventor will be filing on behalf of the statutory inventor. That is if they are not filing for themselves. But if you are filing for yourself, like you're not working with an organization, you've come up with this invention and you want to get a patent application for it as you, then you will be the inventor, both the true inventor and the statutory inventor. Just like copyright again. If you are the one doing your work, like it's not a commissioned work, that means you'll be both the owner and the author. I hope that explains it better, Beatrice.
Okay, Beatrice, I hope you got
Get it now?
Beatrice, I hope you got Miss Chukurat's explanation. Right. So we'll be taking pictures now. Thank you so much, Ma, for helping us out with questions. We'll be taking pictures now. So please, mentees, if you can, let's turn on our videos for our picture time. All right. Thank you, Oluwadamilola. Thank you. So our moderator will be doing that shortly.
Okay. In one or Chika, are you online? Chika, are you online? All right. Okay. Okay, I think we have our screenshot. Um,
Yes, we are done with our
Okay, thank you for giving us a little bit to see. So, I'm not sure Mr. Rakesh is online yet. It's not online. I think we have to adjourn the meeting at this point. In the absence of any further questions from the meeting, we appreciate everyone for being present in today's session, and most especially our mentor for for the men for the mentorship of today. It has indeed been an unforgettable one and a practical one of everyone today. Even as a moderator, I've learned a lot, and I believe the mentees have learned greatly too. We really appreciate the time. So we and the mentees too. Thank you for being here, for creating the time. I believe you have learned, and I believe you are also going to make this kind of impact in the future. In the absence of any question, and since we don't have Mr. Rakesh, we'll be closing on the session for today. So see you next time. Don't forget to share what you have learned on your different social platforms and tag our mentors. Also remember, registration is still ongoing. Tell your friends and colleagues to also register and benefit from this great mentorship. Okay. See you all later. Bye bye.